Hi, I'm Michelle Kaminsky. I'm an Associate Director of the School of Human Resources and Labor Relations at Michigan State University. I'd like to talk with you today a little bit about the potential repeal of right-to-work legislation here in Michigan. Right-to-work is legislation that's harmful to unions, and so the repeal of it would be beneficial. This is happening at a time when labor unions are increasingly popular in the United States. Every year, the Gallup organization asks Americans whether they approve or disapprove of unions. The most recent data shows that 71% of Americans said that they approve of labor unions. That's the highest that number's been since the middle of the 1960s. So why are unions popular? If you're watching this, odds are pretty good you know the answer to that question. One of the reasons unions are popular is that unionized workers make significantly more money than non-union workers. In recent years, they've made between $9,000 and $10,000 a year more on average than non-union workers. Union contracts also bring better health care and better pensions. And unions have some non-monetary benefits as well. Most importantly, they provide more voice to people in the workplace. So if someone feels like they've been mistreated or feel like something's not right about what's going on in the workplace, they can go to their union, they can have someone advocate for them and represent them, and they can do this without fear of reprisal for speaking out. And so it provides people with a lot of psychological security as well as the financial security that comes with a unionized job. And I think another thing that's an advantage about labor unions that not so many people know is that the way wages are determined under a union contract has the effect of decreasing the wage discrimination that we see by race and gender in this country. So overall, women in the United States make about 82 or 83% of what men make, but unionized women make about 90% of what unionized men make. And they make as much as non-union men make. And we see similar patterns in terms of decreasing the gap for workers of color compared to whites as well. So unions are an institution that play a significant role in creating more equality within our work organizations. So we said that right-to-work legislation is harmful to unions, but I find that right-to-work legislation is something that's not so well understood. And so how actually does it harm labor unions? Well, I think the first thing to understand is to get past the name. As Martin Luther King said, right to work is just an example of doublespeak, and don't be fooled by it. It provides no rights and no work. It does not guarantee anyone a job. So what does it do? Well, it bans something in a union contract. So the way union contracts work, contracts are negotiated between the representatives of the employees, that is the union, and management. And typically, the union and management do the negotiation, and the membership body overall votes on the contract. It's a form of democracy in the workplace. There is something in non-right-to-work states, a clause in the contract. It's usually called the Union Security Clause. And that clause might say something like this. When somebody's hired in after they pass their probationary period, which might be 30, 60, or 90 days, then if they become kind of a full-time permanent employee, they are required to pay union dues to cover the cost of bargaining and administering the contract. It's that contract that pays them more money and gives them better benefits. And so the cost of having people available to negotiate the contract and then also to enforce the contract to make sure that it's followed for its duration are what those dues dollars go for. And so that clause is typically bargained. It doesn't have to be in a contract, but it would typically be proposed by the union, agreed to by management, and voted on by the membership. So everybody would have agreed to it. Right-to-work legislation says you cannot have a clause like that in your contract. And so when Michigan became a right-to-work state, the law went into effect 10 years ago in 2013, unions had to do something different about that clause in their contract. They had to negotiate something different. And I'll come back to this at the end of this at the end of this video and say a little bit more about that. But basically, the purpose of Right to Work is to weaken the union by reducing their financial support. Also, to reduce their support. Unions get their strength from the solidarity of the membership. And if some of the people who are covered by the contract are not really supporting the union, that also hurts the union's strength and hurts their ability to get good wages and benefits in the future. So one thing I find, though, about Right to Work is that there are some really common myths about it out there, and I'd like to address 3 of those. The first is that the union doesn't have to represent people who don't pay dues. That's simply not true. That's something that's based on our federal labor law. That is something that's just not possible, and any union that tries to do that can be fined. Basically, everybody who is in the job categories covered by the contract gets the same wages, benefits, et cetera, that's described in the contract. And whether they pay dues or not, and if a non-dues paying employee who's covered by the contract wants to go to the union and say, I've been mistreated, I applied for a different shift and I should have gotten it and I didn't, or I got passed over for overtime, or I was disciplined or even fired for a reason that I think was unjust, then that person can go to the union and the union has to represent them as equally as if they were a full dues paying member. So they cannot discriminate between a non-dues paying member and a dues paying member. If they do, then they are in violation of something called the duty of fair representation, and they can they can have charges filed against them for that, and they can possibly be subject to a fine. And one of the things that I think dues-paying members particularly dislike is that when it comes to the grievance procedure, if a non-dues payer has a case that goes to arbitration, then it's not just the time of the union leadership that goes into representing them. There may also be a financial expenditure, for example, to pay the arbitrator and perhaps to pay attorneys who might need to be involved in the case. And so the dues money of people who are full dues payers is used directly to support the benefit of the non-dues payers. And that's something that I think many people find to be unfair. So again, just to recap, the duty of fair representation says that the union is legally obligated to represent non-dues payers and dues payers equally. The second myth that I want to mention is that you'll often hear people say, well, I don't want my dues money going to support political candidates that I don't agree with. And there's a misunderstanding embedded in that statement. The fact is that union dues cannot be used to support political candidates. It's true that unions are very involved in politics, and anybody who's around a union for any amount of time knows that they are frequently collecting voluntary donations for their PAC fund, which may go by different names, COPE, CAP, PAC, a variety of different names, that are separate funds that are made up of voluntary contributions. So that's right, it doesn't come out of the dues. It's members or others may donate to those funds on a voluntary basis. Dues money does not go to support political candidates. The third myth that I want to mention has to do with new employers coming to the state. We'll sometimes hear in the public debate about right to work, we'll sometimes hear people say that, new employers will only go to states that are not that are right to work states. And if we repeal this, nobody's going to build any new facilities in Michigan. Well, that's just not true. For many years, some business publications have been surveying employers who are making decisions about where to locate new facilities. And the top things on their list are things like having the availability of a skilled workforce, having access to roads, airports, being near other firms in their industry that might be suppliers or customers for them. So there are a lot of things that employers take into consideration about locating a new facility. And it's possible that right to work's on that list, but it's nowhere near the top of the list. It's pretty far down, I would say. So I think that those are some myths about right to work. And next, I'd like to turn to what the implications are if right to work is ultimately repealed in Michigan, and it's on track to be repealed. So what are the implications for labor unions? So first of all, the answer is different for public and private sector unions. So for private sector unions, they would have had a clause in their contract before right to work that's perhaps, if it was negotiated, that said that that people covered by the contract had to pay dues. And then when right to work was went into effect in 2013, they would have had to have renegotiated that clause in their subsequent contracts. And what happens next depends on what they negotiated. If the union was particularly strong, they may have negotiated a clause that says if right to work legislation is overturned, then as soon as possible, members or people covered by the contract will be required to pay dues. Or it might be that they will have to renegotiate that clause at the next contract expiration date. So what's going to happen is not going to be the same for every single private sector union. It depends on what that union security clause says in your contract. So I encourage you to go look at your contract and check that out. So second, what about the public sector? Well, even if right to work is ultimately repealed here in Michigan, which looks like it will be, it won't have an impact on the public sector. And why not? That's because of the Supreme Court ruling, Janus versus AFSCME, that effectively made the entire public sector a right to work workforce in the United States. So the state law cannot supersede the Supreme Court decision. So unless that Supreme Court decision is at some point overturned, then the public sector is going to remain right to work for the foreseeable future. So to wrap up, I guess I want to say that unions are increasingly popular. Right to work legislation is harmful to unions, and the repeal of right to work will be beneficial to unions here in Michigan, but that impact will be felt more strongly within the private sector than within the public sector. So I hope this has clarified some things for you, and please feel free to give me an email if you have any other questions.